Hello friends, in the series on the income tax cases, today we will discuss a case which is based on section 263 proceedings. Section 263 gives a right to the Principal Commissioner of Income Tax to do a revision of an assessment order if he finds that the order is erroneous and prejudicial to the revenue. Broadly speaking, the assessment order passed by assessing officer is erroneous if he has not done inquiry on any issue for passing the assessment order. But the both conditions should be cumulatively satisfied for doing a revision under section 263. The issue before the Honorable Apex Court in the present case was that if the Principal Commissioner of Income Tax takes a view that the assessment order is erroneous and prejudicial to the revenue and directs the AO to pass a fresh order, then does it mean that the assessing officer has to pass a order making the addition on the issue suggested by the Principal Commissioner of Income Tax? This issue has been taken up by the Apex Court in the case of Principal Commissioner of Income Tax versus Rani, Sati, Agro Tech Private Limited. This case is reported in 478 ITR at page number 229, and the date of the judgment is 17th April 2025. The present case was related to the assessment year 12-13. The issue of share capital increased was there in the previous year relevant to the assessment year 12-13. The assessing officer accepted the share capital and passed the assessment order. When the Principal Commissioner of Income Tax was going through the assessment order, he was of the considered view that the assessing officer has not made inquiry for verifying the genuineness, creditworthiness and identity of the share subscriber. So he accordingly passed an order to do a fresh order for the assessment proceedings. The assessee participated in the fresh assessment proceedings. The AO made detailed inquiry, extensive inquiry, and again the assessing officer made a mind that the share capital is genuine and he accepted the share capital and passed an assessment order accordingly. The Principal Commissioner of Income Tax again passed an order for doing the revision under section 263 on the pretext that the second assessment order is also erroneous and prejudicial to the revenue. Now this time the assessee preferred an appeal to the tribunal for quashing of the second revision proceedings on the ground that the second assessment order has been passed after doing an extensive inquiry. So the first limb to be satisfied for initiating the revision proceedings does not satisfy, because now the order is not erroneous because the extensive inquiry has been done. The tribunal examined the facts and found that the second assessment order has been passed by with adequate inquiry, with extensive inquiry. So the assessment order is not erroneous in any way. But the revenue was harping on the view that once the 263 proceedings are initiated on an issue, then AO is bound to make the addition on that point. So the tribunal was not with the revenue on that particular ground. So accordingly the tribunal quashed the assessment proceedings. The revenue filed the appeal in the High Court. The High Court also upheld the order of the tribunal. So accordingly, as usual, without going into the merits of the case, whether it is a fit case for going into the SLP or not, the revenue filed the appeal in the Supreme Court, and the Supreme Court also upheld the order of the tribunal and the High Court. Friends, this case is a perfect example that how much appetite the revenue has for litigation. When the assessing officer has made the inquiry, just because the Principal Commissioner of Income Tax is of the view that the addition has not been made on an issue suggested by him they drag the matter to the Supreme Court. Examine. The assessing officer has examined all the facts of the share capital and then he passed the order. Even then, the revenue did the revision proceeding second times and after all lost its case in the Supreme Court also. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Rani Sati Agro Tech Private Limited, and this case is reported in 478 ITR at page number 229, and the date of the judgment is 17th April 2025. Thank you, friends.